Assuming we have a world in which they can actually lodge the objections that you say that they have, my question is, isn't that enough to remedy their issue? Do we have to also entertain your argument that no one else in the world can have this drug, or no one else in America should have this drug in order to protect your clients?
So again, Your Honor, it's not possible given the emergency nature of these situations.
Counsel, let me interrupt there. I'm sorry. Recently, I think what Justice Jackson's alluding to, we've had, one might call it a rash of universal injunctions or vacatures. And this case seems like a prime example of turning what could be a small lawsuit into a nationwide legislative assembly on an FDA rule or any other federal government action. Thoughts?
Yes, Your Honor. Again, I have to say that I think it's impracticable to raise a conscious objection. But even spotting that, I think the district court remedy here was perfectly appropriate under Section 705.
In 2022, Erin Hawley was part of the team that got Roe v. Wade overturned. Today, she acted as the lead attorney on trying to roll back access to the abortion pill, which now accounts for nearly 2/3 of abortions nationwide, according to the Guttmacher Institute. Joining us now, attorney for the Alliance for Hippocratic Medicine, Erin Morrow Hawley, who represents a group of anti-abortion doctors and conservative medical associations that claim the abortion pill is a danger to women. Erin, it's really good to have you. Congratulations on arguing your first case in front of the Supreme Court.
Thanks so much for having me. Glad to be here.
Good. I just played Justice Gorsuch pressing you on why your 7 clients, also Justice Jackson, should have the right to impose a nationwide injunction on the rest of the country when a more tailored remedy would be more appropriate. Why can't your clients just opt out of abortion care, performing abortions, as the justices suggested?
So I think one of the most shocking things that we heard today was from the Department of Justice, and the Department of Justice said that no one would be able to challenge FDA's reckless removal of safeguards, even admitting that if they were unlawful, that wouldn't matter according to DOJ, because no one could challenge these provisions. And that's not usually how the law works.
But let me ask you again, why can't your clients, your doctors, just opt out of performing abortions? They're allowed to. There's a statute that allows them to.
So 2 reasons. So we are delighted to hear the federal government concede in court today that our clients are entitled to federal conscience protections. They've said directly the opposite in other court cases involving emergency situations. So we agree these federal conscience protections should apply. But the fact of the matter is that these are emergency situations. You may not know until you're in the operating room whether or not it's a miscarriage or an abortion that has taken place. And so it's really impracticable for these doctors to have a conscious objection up front.
Why could your doctors not have a discussion with the hospital beforehand to say that I blanket will not be involved in any of these emergency procedures where that could be a question? That is also allowed.
So most of our doctors are OBGYN hospitalists, which means that they spend most of their time on the labor and delivery floor. But when there's an OB emergency, they're called to the operating room. They are the doctor on call to go down to take care of these sorts of emergencies. Again, they won't know before or after or until they get in the room whether it's a miscarriage or something else. In addition, the FDA really was saying before the Supreme Court today that even acknowledging that 1 in 25 women go to the emergency room after taking mifepristone, that didn't matter because no one could challenge it. That's a scary view of administrative law.
But again, I'm going to ask the same question, because even if they are hospitalists, and I understand what a hospitalist does, I know there's a certain on-call schedule, but if they have agreed to not be a part of a procedure where this may be in question, the hospital would have to employ somebody else along with that person in order to perform that procedure. So there's a way for them to opt out of this that doesn't require a nationwide injunction on a pill, because a handful of doctors are worried that they may in the future be involved in something that they don't agree with because of their religious beliefs.
So I think you said something really important there, and that's that this case is not about access. The only thing that is at issue in this case is whether women who choose to take mifepristone will take it according to the protections that just a few years ago FDA called both necessary and minimally burdensome. And this includes an in-person visit to screen for things like ectopic pregnancies, as well as accurately assess gestational age, things that regardless of one's views on abortion, we should agree that women are entitled to.
My team and I have read through the declarations that you included in your brief. I know you were asked about them by a number of the justices. Can you just clear something up, because I was confused? Have any of your clients performed an abortion against their will?
So I think there was some confusion as to the breadth of our conscience objections. Our doctors object not only to actually completing an abortion and taking an unborn life, but also to scraping out a woman's uterus of baby parts and pregnancy tissue, those sorts of things. And again, those are things that the government conceded in this case are conscience rights. But what it said is something new. It didn't take that position in other federal litigation. And it's really something to require doctors to obtain these conscious objections when, until recently, the Department of Justice has been saying that they're not entitled to them.
But have any of your clients actually performed any of those procedures against their will?
They've performed them, yes. We have a number of declarants that have performed, they're called D&C abortions, and they have performed those, yes.
I didn't see that in the declaration, specifically that they had performed D&Cs for abortions. It wasn't clear that they were for abortions, but they could have potentially been for miscarriages.
I don't think that's correct. The context of those was talking about abortion drug harm. And each of those declarations were talking about women that they had seen suffering from abortion drug harm. And again, when we look at FDA's own numbers, we know that 1 in 25 women go to the emergency room. We know that up to 7% of them require surgical intervention for either bleeding or an ongoing pregnancy. That's not a small number of women, especially when you factor in that 650 million women, nearly 650 million women, take chemical abortion drugs each year.
You brought up the Comstock Act in your brief. It was brought up by the justices today. Is the goal of this litigation to take us one step closer to banning abortion access nationwide?
No. At issue before the Supreme Court is whether or not when women choose to take abortion drugs, they do so with the protections that until very recently the FDA said was both necessary and minimally burdensome. Again, regardless of one's views on abortion, we should all be able to agree that the drug company profits should not trump women's health.
Then why bring up the Comstock Act?
So the Comstock Act prohibits the mailing of abortion drugs, which is precisely what the FDA allowed in 2021. And we think that violates the Comstock Act. We also think it violates the Administrative Procedure Act. When FDA did that, it relied on studies that were, quote, not adequate. That's not what we require of agencies, especially when they're regulating important things like women's health.
The Comstock Act can also be used to stop any equipment that is used for abortions to be mailed nationwide. If you're able to use the Comstock Act here, that is opening the door to stopping medical equipment being crossed state lines, which would open the door to abortion being illegal across the entire country.
I don't think that's a correct interpretation of the Comstock Act. What the Comstock Act prohibits is mailing things if they're designed, intended, or adapted for causing abortion. So if it was a general surgical implement, that could be mailed to a medical device store, and Planned Parenthood could go pick it up there. So again, what is at access in this case is not abortion, but rather safeguards to women's health.
Erin Mauro-Hawley, thank you very much for joining us. We appreciate it. Again, congratulations on arguing your first case in front of the Supreme Court. It's quite a milestone.
Thanks for having me.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.